Welcome back. We're on episode number 12 of Run It By My Lawyer. It's been a good week. A lot of things have been happening in the news. And today I'm going to talk about this new law in Florida, the Don't Say Gay bill, as it's coined by a lot of the people who oppose it. It's going into effect in Florida, Alabama, and a lot of states are kind of picking up this steam. I will say this, it definitely makes for great sound bites by the proponents. Here, let's listen to Governor DeSantis real quick.
And so in Florida, we will make sure that parents can send their kids to school to get an education, not an indoctrination.
That was what you just heard from is Florida Governor Ron DeSantis. And I will say this, he does have a very impressive background. My prediction is that or not just my prediction, but a lot of people think that Governor DeSantis will run for president very soon. Just a kind of a few things you may have not known about Governor DeSantis of Florida. So his ancestors from about 100 years plus ago came to the United States from Italy. And Ron DeSantis himself grew up in Florida. He was a good baseball player. In fact, he played for the Yale University baseball team as an outfielder when he went to college. And then from there, after college, he taught for a year. I think it was history. And then he went on to Harvard Law School. Now, this is where it gets interesting. After he graduated from Harvard Law School, instead of taking that big corporate law firm job, he worked for the Navy as a JAG officer, which is like a naval attorney, you could say. All right. So that was pretty great. He took a government job as opposed to the big law firm job out of Harvard Law School. His credentials in the Navy was very good as an attorney. He became a lieutenant and he was a prosecutor for the Navy. And at one point, he was the special attorney, legal counselor for the Navy SEALs. And then he was, in Iraq, kind of like as the legal counsel for the Navy SEALs. Then in 2012, he ran for Congress in Florida and he won, like right out of the gate. He won. And then in 2018, 6 years later, he ran for governor and he won on his first attempt, and he was heavily endorsed by then President Donald Trump, which helped him a lot in his run for governor. And now today being April 13, 2022, let's see if and when Governor DeSantis runs for president. One of the things that he's doing that's greatly helping himself is kind of like introducing these very kind of conservative, legislation. Now, as most of you know, so I've been an attorney for over 21 years, and I printed this, the actual wording of this law in Florida, and I was able to read all 7 pages with a lot of enthusiasm, and I want to go through now the law itself and explain it, and kind of like go through the implementation and the specifics of the law. All right. As an attorney, us lawyers, we actually like to read this nitty gritty and kind of anticipate how future courts and future legislatures and things like that will address this law. Okay. Now, a few things that are important to note. All right. The theory, it goes on in the law, is that they want parents to be more involved in the student's education, and they want parents to be the ultimate kind of influencer. Okay, not an Instagram influencer, but like they want the parent to be the ultimate influencer when it comes to their kids' gender identity and sexual orientation. That's the kind of theory. All right, so let's look at how this is worded and how it's implemented. All right, first order of business is that the law says any sort of healthcare forms or healthcare questionnaires or how the school will administer healthcare has to be laid out and explained to the parents. Okay. I highly doubt how that wasn't in effect already. So that's fine. And then where it gets kind of where people start taking issue with it, it goes like this. Okay. The law states that anytime if a student, up to age 18, right, talks to a teacher or a healthcare, professional or a social worker or a counselor at the school, any sort of discussion of any sort, and it comes to healthcare, the parent has to be notified. Okay. And that is pretty severe in the sense that what if the student says, is this just between us or anything like that? According to the law, it is not just between us, okay? Because according to the law, the school district, here's what it says: the school district personnel may not discourage or prohibit parental notification of and involvement in critical decisions affecting the student's mental, emotional, or physical health or well-being. So, according to the law, so anytime a student has any sort of important conversation about that student's emotional, physical, anything, the letter of the law says that the school has to notify the parents. Okay. Now, there is an exception, okay? And then the way it reads goes like this. This subparagraph does not prohibit a school district from adopting procedures that permit school personnel, here we go, to withhold such information from a parent if a reasonably prudent person would believe that disclosure would result in abuse, abandonment, or neglect, as those terms are defined. Okay. So this is where it gets, this is the first instance that I want to bring up of something that's very vague. All right. And I'm going to say this a few times today. Lawyers love vague. All right. Because when something is vague, then there's a lot of dispute in it. Okay. So here it says that, so let's say a student says, I'm feeling, whatever, I'm depressed. I want to come out as gay. I mean, that's the people want to, emphasize, right? Or whatever it is. I'm my gender, I'm a boy, but I want to be a girl, whatever it is, right? So here it is, the law places upon the teacher or school administrator to say, I have to notify the parents that this kid is talking about gayness or gender identity or straightness, okay? Whatever it is, because it says here any sort of sexual orientation, whether it's straight or gay. So, I mean, it could be a guy that talks about how much he loves someone, a girl, or it could be, a girl talks about a guy or a guy talking about a guy, whatever it is, okay? If the school administrator thinks that telling the parents will result in abuse, neglect, or abandonment, then the school official, as long as it's reasonable, can withhold that information from the parent. All right. And again, like I said, lawyers love vague, right? Because it's kind of vague. Like, what does abandonment mean? Or what would a reasonable person think would result in a parent abandoning or neglecting the kid after learning of these things? All right. So lawyers love vague. Probably the one thing that lawyers love more than vague is if a law on its face has a flaw. All right. Okay, it says here, as those terms are defined, all right, and it's going to say in the law, it's going to say that there's going to be like pursuant to certain standards, all right. And then section 2 of the law says the following. It says by June 30, 2023, all right, the Department of Education of Florida shall review and update as necessary school counseling frameworks and standards, educator practices and professional conduct principles, and any other student services personnel guidelines, standards, or frameworks. So that has to be done by June 30, 2023. And then section 3 says, this act shall take effect July 1, 2022. Okay. So, as the way I see it, there's a flaw on the face. What lawyers mean by on the face, it's like in the actual wording. So the law says that the teachers are supposed to adhere to these certain standards that are gonna be written out and implemented, and those standards have to be done by June 30, 2023. However, then Section 3 says the law shall take effect July 2022. So what the heck happens during that 1 year, right? I think that's going to be litigated and something's going to go wrong there at least just with those terms. I could be wrong. Maybe a judge will say, no, that makes perfect sense. The teacher in 2022 should know what the standards will be in the year 2023, right? That could, a judge could say that, I suppose. Okay. Then we get into kind of some more nitty gritty. All right. It says in the law, classroom instruction by school personnel or third parties on sexual orientation or gender identity, here we go, may not occur in kindergarten through grade 3 or in a manner that is not age appropriate or developmentally appropriate for students in accordance with the standards. All right. Okay. Now, again, remember what I said. I said I'm going to say it a lot of times, so forgive me. Lawyers love vague, right? It says here, okay, so no talk of sexual orientation or gender identity in any school instruction for kindergarten through third grade. All right, which I can't imagine if that was already being discussed. There was some sort of curriculum, but whatever. Now they're saying definitely not. Okay, that is not that vague. But here's where it gets vague. Or in a manner that is not age appropriate. Okay. Wow. Who decides age appropriate? Okay. And then let me throw a few things out there for you. For example, biology class, right? So in biology class, at least when I was in high school, it comes up, right? Reproduction, okay. And, what's it called? How the process begins, this and that of reproduction and the biology behind it. So when would be the age appropriate time to discuss that? All right. It doesn't say here. So that's going to be something that's going to be up for debate. Other things that are going to be litigated up for debate is, as the law says here, sexual orientation or gender identity. Notice it doesn't say anything about homosexuality. It says sexual identification. So that is whether it's straight or homosexual, right? So here, what if there's a discussion about a husband and wife that is or a story, of a man who loves a woman, or anything like that. That would be a story about sexual orientation, right? Or a story about somebody that's like a man and he has a journey in the story and it's like a manly journey, okay? Or whatever it is. That could be a story about a gender identity, right? It doesn't say that it has to be a gender identity crisis, any gender identity discussion. So I was thinking Romeo and Juliet. A lot of times the 6th and 7th grade, they discussed Romeo and Juliet. Obviously, a story about sexual orientation. You got a heterosexual couple, right? So there could be a lot of debate in terms of when then that will be appropriate, developmentally appropriate or age appropriate. So there's going to be a lot of discussion about that. Also, as I recall in high school, I went to high school a long time ago. In fact, a different century ago. Okay. So we had the debate class or in social sciences debate class. So one of the topics was abortion. So in theory, what's the deal? Are they going to have to change the debate topics? That will be an issue that gets debated as time goes on, right? The other thing, okay. So obviously, as I'm mentioning, there are all these the different how do we, what about this? What about that? Like in terms of anytime when lawyers look at these laws, we kind of start thinking, well, what's going to happen if this comes up, or what happens if that comes up? What happens if a teacher says, here's we're talking about history of legislatures, and let's talk about Harvey Milk, as one of the legislatures we discuss, right? And then somebody says, well, why did that teacher talk about Harvey Milk, an openly gay, politician? And then the teacher says, well, I didn't talk about him being openly gay. I just talked about some of the things that he promoted and some of the laws that he wanted to pass, right? And then there's a dispute in the sense that, a parent gets all upset about it. Okay, so then I wanted to see, well, what does the law address this kind of conflict resolution. All right. And it does. And here's how it addresses that. So let's say I'm a parent, right? I have 3 kids, right? And I get upset, like, my son learned about Harvey Milk, right? And I'm upset about this. Or, another parent's like, Romeo and Juliet, that's gender identity. That is sexual orientation. I'm upset. Okay. So here's the conflict resolution. Here's what the letter of the law says. All right. Each school district shall adopt procedures for a parent to notify the principal regarding concerns about this law. Okay. And the process for resolving those concerns within 7 calendar days. Okay, so here's the school. If a parent addresses the school and sends an email or a complaint form or whatever saying that, this law was violated, the school, according to this, the process for resolving those concerns within 7 calendar days. So within 7 days, the school has to come up with a plan that will address that parent's concern. And then it says, at a minimum, the procedures must require that within 30 days after notification, that the problem gets resolved. So the letter of the law goes like this. If a parent complains, hey, principal, why did they talk about, Harvey Milk here? Okay. Or why did they talk about Romeo and Juliet or why is biology class talking about a penis? All right. Then the school has to, within 7 days, have a plan that will address the parent's concern within 30 days. Okay. So then within 30 days, that concern must be addressed with it, which, gosh, in terms of the law, 30 days is fast, right? I would hate to be a lawyer that's like, okay, you have to come up with how this is addressed and resolved within 30 days. Okay. That is fast. And it's calendar days. So if that 30 days is on during Christmas, whatever, forget Christmas, I got to address it. Okay. Then there's a decision that has to be made within 30 days, right? And that decision then has to be, given to the parent and the school district. If the parent is not happy with the decision, then the law has the next step in terms of the kind of complaint process. All right. The parent then has an option. The parent can request a commissioner of education be appointed as a special magistrate to address the concern. Okay, so the concern being, why did they teach my son about a penis and he's only 12 or 14 or whatever, right? Then the school says, okay, that's just part of biology class. Joe Samo, that's me. I say, I am not happy with your decision that you're going to keep talking about penises to juniors in high school. Then the school has to appoint a commissioner of education as a special magistrate to discuss this concern about the school talking about a penis in biology class. Then that special magistrate has to listen to the facts, listen to the parents, listen to the school. And it's kind of like a quasi trial that magistrate has to do. And then within 30 days, there has to be a resolution by that magistrate. Okay. And then that has to be, documented. And what does it say? And the beautiful part is the cost of the special magistrate shall be borne by the school district. All right. Which means anytime a parent wants to, petition this, the school has to hire this special judge, which, by the way, we call that in law. There's ways to attack a law. And one of the ways is the correct way, which is attacking the law and maybe the constitutionality of the law. And then another way is just by kind of like picking at kind of some sort of problem, like a little loophole in the law, and kind of like messing with it so much. Like, what if a parent every day makes a complaint, right? And you know who those parents are, all right? And they keep making complaints. What's the school, according to the letter of the law, every single time a parent makes a freaking complaint, they have to hire a special magistrate and pay for the special magistrate, all right? So if a parent doesn't like this law, they are within their rights to make 500 complaints every single day They say, oh, they talked about this in biology class. Oh, they talked about this story. Oh, you read the Great Gatsby? Isn't that a story about a man who was in love with a woman and then starts having these crazy parties so that he could find that woman? That sounds like a lot of sexual orientation, heterosexual talk. I'm upset, right? And so the school will have to keep hiring these magistrates to address that and pay for it. Okay. So that could, right, that by itself could be a big problem in the law. The next thing that the parent can do, and this one is dirty, and I'm going to explain what I mean. Here we go. You guys are okay. I hope you're sitting down. I hope you're not driving while you're listening to this, because you may need to pull over. It says that the parent, if they are not happy with a decision that the school makes, the parent can bring an action against the school district to obtain a declaratory judgment that the school district procedure or practice violates this law, and the parent can seek injunctive relief. Now, so that means the parent has the right to petition a court to stop the practice. So the parent can say, we want the biology class to start in the senior year in high school, not the junior year in high school, or whatever it is. We don't want the Great Gatsby discussed anymore because there's a lot of heterosexuality in the Great Gatsby and gender identity in the Great Gatsby, right? So then they could file a lawsuit with the court to try to stop that action, okay? Or if, whatever, one counselor heard from a student, the student was worried about some sort of identity issue or a sexual orientation issue, and that counselor didn't tell the parents because that counselor thought that, there would be neglect or abuse at home. And then the parents, when they learned about it, they challenged it and they filed a lawsuit. All right. So all of that is allowed. Here's where it gets dirty. A court may award damages and shall award reasonable attorney fees and court costs to a parent who receives relief from a court. Oh, when I read this is dirty for lawyers. Lawyers love that. We call that there's an attorney fees provision. That's what we call it. And it's a beautiful provision for lawyers because what it means is if a lawyer represents a parent and files a lawsuit, and if they get any sort of relief from the court, then that lawyer, the parents don't even have to pay the lawyer. The lawyer can get the money straight from the school district. Okay. And the beauty is that it doesn't have a reciprocal clause, which means if that parent loses, then that parent has to pay the school district. It doesn't have that. It only has it if the parent wins, the school district has to pay the legal fees for the lawyers. Now, in reality, what this does is it gives lawyers like a kind of almost like an incentive, right? Like for any sports people out there, if there was something like run a mile in less than 5 minutes and get $1,000, right? Whatever. This is like sue the school, and if you win, you get $500,000 in legal fees. Okay. So a lot of lawyers, they can finance these disputes, not even from the parents. They could finance the disputes against the school by asking the school to pay their legal fees. Okay. So like I said, when lawyers read an attorney fees provision in a statute that says a court may award reasonable attorney fees, okay, like I said, that is dirty. That's like dirtier than pornography. When I read that, I had to take a shower after I read that. That was so dirty. In fact, when I go home, I'm going to hide this under the bed so that the kids don't see how dirty it is, right? That provision itself will end up leading, it encourages a lot of lawsuits. Imagine if the law said, if you lose, you have to pay the school's legal fees, right? If it said that, then, it could deter litigation. It could have said nothing, but instead it encouraged litigation. All right, so let's keep going. Now, the next order of business, this is what's going to happen. The law takes into effect on July 1. So today's April. So we're talking about about 3 more months. Already there's lawsuits against this law. And this is how it's going to play out, okay? The lawsuits that are going to start happening. And there's going to be a bunch, okay? It's going to be attacked on federal constitutional grounds, okay? It will not likely be fought on the state of Florida constitutional grounds because the state of Florida I don't want to say has no constitution because it does, but it clearly will not. I do not see the state of Florida court uh, rejecting this law. Okay, if it gets rejected or challenged appropriately, it'll be on a federal level. Okay, so to give you a little background, this is how it goes. All right, a lot of you will recall there was these debates and laws, blah blah blah, about same-sex marriage. Okay, and many states passed laws that disallowed same-sex marriage. All right, including California. It was Proposition 8 about 14, 15 years ago, and Proposition 8 said that the state can will not allow same-sex marriages to get licenses and things like that. All right, that law was challenged, on constitutional grounds, both California Constitution and federal Constitution. The California Supreme Court said that it does not violate the California Constitution to ban same-sex marriage. The way it was struck down was the federal court. There was the Ninth Circuit Supreme Court said that law, the Proposition 8, did violate the federal Constitution, the Constitution, and specifically what's called the Equal Protection Clause, which is you can't. It's like discrimination against a protected class is not allowed unless there's some sort of like strict scrutiny of like the state has a good reason to discriminate type of thing. Okay, and there they found there wasn't a good reason to discriminate, so that it violated the Equal Protection Clause, and then there was the federal government that struck down at least the California law. But there was other states, Michigan, Ohio, Kentucky, Tennessee, where the same kind of law was in effect about this. There's no allowance for a marriage certificate to a same-sex marriage, like man marrying a man or a woman marrying a woman, right? So that was all challenged and ultimately went to the Supreme Court, and in a narrow 5-4 decision, which means there's 9 Supreme Court justices, 5 ruled that a ban on same-sex marriage violates the federal Constitution. And 4 of the Supreme Court justices said in 2015, not that long ago, 4 of them said that a ban of same-sex marriage by a state does not violate the federal Constitution. It's fine, right? So this law will be challenged the same way. It'll go to federal court with this, there will be a couple arguments. One of them will be this equal protection, saying that it's kind of the intent of the law and the effect of the law will be to kind of discriminate against gay students, right? Or transgender students. That's the real effect of the law, because they can't talk about it. They can't be open about it. They can't confide in a teacher or counselor about it because they'll tell the parents, and it could lead to, problems at home, things like that, right? So it's going to be challenged on those grounds. And then probably another challenge will be some sort of a free speech issue by teachers. For example, let's say we have a 5th grade teacher, a guy who is going to get married to his girlfriend. In theory, he can't talk about it maybe in the class, or he can't bring it up, or he can't explain it, or he can't be proud of it or whatever. So maybe he will file something saying, hey, you're infringing on my free speech to kind of go around and talk about this to my students. Or it could be a gay teacher that says the same thing, right? So, or a gay teacher that says, okay, fine, I won't talk about it in school, but I'm going to put it all over TikTok and MikTok and DickTok. Ooh, I don't know if there's a TikTok, but that we might be onto a good idea here. Anyway, okay, so another teacher might do all that, and then they'll say, well, you can't ban me from doing this because this is my free speech right. So I think it'll be challenged on discrimination grounds, the Equal Protection Clause, and potentially also on the free speech kind of grounds for teachers. Okay, it could maybe students who want to kind of say gay all day, right? It could be challenged by them also as free speech rights. I don't know. Or no, I'm sorry. It probably will be challenged. I don't know if they would win that. Okay. Okay. So anyway, so that's going to be the future of this law. There's going to be a lot of challenges, and I assure you, I'm like worried about it because I don't want to come across the same way. But in a way, as a lawyer, I love this law because a lot of fellow lawyers are going to make a lot of money both fighting and defending it. Okay. And a lot of judges will get a lot of judge time, right? Adjudicating it. Okay. So it's going to go down the pipe. It's going to be definitely challenged. Now, here's the deal. Okay. 2015 is, in terms of the Supreme Court, is, you can say, generations ago. All right. And what the heck do I mean by generations ago? Do you recall earlier I said in 2015, when the United States Supreme Court ruled that banning same-sex marriage violates the Equal Protection Clause of the Constitution? It was a narrow decision. A narrow decision means 5-4. It would be like in a boxing match, two judges said that this boxer won, and one judge said that boxer won. Okay, that's like a narrow decision. Okay, here's the same thing. It's even narrower. It's 5-4, right? Since 2015, the composition of the Supreme Court justices has changed. And I'm going to explain how. Since 2015, we lost the following justices: Scalia, Kennedy, and Ruth Bader Ginsburg. Okay. Kennedy was appointed by Reagan, but some would say that, he voted, or not voted, but he ruled that same-sex marriage was unconstitutional. He was, you could say liberal or whatever the heck you want to say. But anyway, so we lost those three justices: Scalia, Kennedy, and Ruth Bader Ginsburg. Okay. So definitely one of them is on what you can call the liberal side, and maybe two, okay, of the three. Now, we lost those three justices, and who has been appointed since then? All of them since 2015 have been Donald Trump justices. Okay. Neil Gorsuch, is that how you pronounce it? Kavanaugh, okay, or Kavanaugh, but as Trump used to always call it, Judge Kavanaugh. He always said Kavanaugh, Judge Kavanaugh. Anyway, so Judge Kavanaugh, that's two, and then Mary Coney Barrett, okay, the Notre Dame law professor. So those three justices are obviously a lot different than at least two of the justices we lost, okay? So the Supreme Court, you could say in today's terms, is a lot more conservative than the court was in 2015. So I think that, and by the way, there is the Joe Biden appointed Judge Jackson, but it doesn't, that one in a way may not really change the composition of the Supreme Court, because Judge Jackson is going to replace Justice Breyer, who was a Bill Clinton appointee. So it doesn't like what we like to say, sway the court. What does sway the court was probably the big one, was replacing Ruth Bader Ginsburg with Justice Coney Barrett. Okay, that one probably changed the court the most in the past few years. So I think, all right, here's the Joe Samo prediction. I believe this one would probably be, if it goes to the United Supreme Court as it stands today, I do not think the United States Supreme Court will rule that this law is unconstitutional. I think the United States Supreme Court will say something like, there's a big parental rights kind of provisions here, kind of like protecting parents' rights to choose how their kids live, and be able to talk to their kids about, sexual identity and sexual orientation and things like that. So they're going to lean on the parental rights. And then they're going to say something like, it doesn't really discriminate against gay students because it doesn't like make them like a lower class citizen or something. And it doesn't like take away a right of theirs like the marriage rights did. And it doesn't necessarily even do it doesn't even address them. It addresses just curriculum about any sexual orientation, whether it be heterosexual or homosexual, or any gender identity, whether it being like, you're born how you're born, or you can change identity, whatever. So they're going to say that it doesn't even discriminate necessarily against these students. So I think that if challenged, I do not see the United States Supreme Court as it sits now overruling this law. Okay. I don't know. Like I said before, I could be wrong. I've been wrong a lot of times. I could be wrong about this too. I'm very interested to know what you folks think. Okay, here's my rendition of the law. I wanted to make sure I focused on the kind of nitty gritty as us lawyers do, and I would love to see what you think.